In a significant judgment by the Supreme Court of India, a bench of Justices Sanjay Kishan Kaul and Rishikesh Roy has ruled that caste and community tensions will be far lesser if educated youngsters are allowed to choose their own life partners. The Supreme Court in this case was hearing an Article 32 petition by a woman from Karnataka who had to elope her residence and marry the man she loved, who hailed from Uttar Pradesh. There were FIRs registered against the husband, and there was a missing persons complaint registered in the case. The bench noted that this entire litigation could have been avoided if the police officers from Karnataka acted in a more responsible way. The court went on to note that the way forward in reducing these caste and community tensions was by having such intercaste marriages. The Supreme Court noted intricacies of marriage lie within a core zone of privacy, which is inviolable, and even matters of faith would have the least effect on them. The right to marry a person of choice was held to be the integral of Article 21 of the Constitution of India. The Supreme Court went on to note educated younger boys and girls are choosing their life partners, which in turn is a departure from the earlier norms of society, where caste and community play a major role. Possibly, this is the way forward where caste and community tensions will reduce by such intermarriage. But in the meantime, these youngsters face threats from the elders, and courts have been coming to the aid of these youngsters. A two-judge bench of Justices Abdul Nazir and Sanjeev Khanna today dismissed all objections raised by the unit holders in the winding up of the 6 debt schemes by Franklin Templeton. The disbursal of 9,122 crores as ordered earlier through the SBI mutual funds will happen as ordered. The Supreme Court held, we hold for the purpose of Clause C to Regulation 18 Clause 15. Consent of unit holders would mean consent by majority of the unit holders who have participated in the poll, and not consent of majority of all the unit holders of the scheme. A Supreme Court bench led by Justice D.Y. Chandrachud today dismissed an appeal preferred by the Northern Railways challenging the decision of the National Consumer Disputes Redressal Commission, which had asked railways to compensate a passenger who lost her bag during a personal travel from Delhi to Secunderabad. Justice Chandrachud noted that the sum involved in this case was only 1,33,000 rupees, and he observed that it was a paltry sum to appeal in the Supreme Court, and thereby the NCDRC ruling was upheld. The railways had primarily claimed that the railways do not bear any responsibility of the luggage or the security of the luggage of a passenger unless the passenger is using the services of the railways to transport such goods. It claimed that the passenger does not fall within the meaning of consumer as defined under the Consumer Protection Act 1986. A Supreme Court bench led by Justice A.M. Khanwilkar today refused to stay the local body polls or the panchayat polls by Andhra Pradesh in the Kotia panchayat, which consists of 28 villages and which has primarily the 3 contested villages on which both Andhra Pradesh and Odisha assert their claims. The Supreme Court was hearing a contempt petition filed by the state of Odisha against the state of Andhra Pradesh for violating a 50-year-old status quo, where it was stated that both the states would not be conducting polls and elections in the contested villages of the Kotia Panchayat. Advocate Mahfouz Naski, who appeared for the state of Andhra Pradesh, has been asked to furnish a response from the state within a week, and this matter would be now taken up on February 19th. Well, lastly, Chief Justice of India, S.A. Bobde-led bench today issued notice to the central government and Twitter communications on a petition by BJP leader Vineet Goenka, who sought to have a mechanism or directions so that centre could form a mechanism in order to check the rate of fake news and unsubstantiated news on social media platforms like Twitter. The advocate appearing in the case, Ashwini Dubey, submitted before the Supreme Court that there was a need for such a mechanism, as certain incidents regarding to the Khalistani movement or to the Republic Day violence which happened in the National Capital Territory of Delhi was also due to the spread of such fake news over the Twitter. Well, that's all from Supreme Court today. Do stay tuned with Supreme Court today on Monday as well. And don't forget to like and share baronbench.com.